Good afternoon, everybody. My name is Mark Trummel, and I'm the chair of Virginia Ability. I'd like to welcome everybody here today. We're pleased to present our program entitled ADA and the Mental Health Crisis. Our speaker is Neil Telegunker, a member of the law firm of Kaufman and Knoles. Neil is a labor and employment attorney who provides practical guidance to employers on compliance with state and federal laws, including the Americans with Disabilities Act, the Age Discrimination in Employment Act, COBRA, the Fair Labor Standards Act, the Family and Medical Leave Act, Title VII of the Civil Rights Act of 1964, USERRA, and the Virginia Wage Payment Act. Clients routinely call Neil for advice before making critical employment decisions. We're excited to hear his thoughts on the mental health issues that many employers are grappling with after the pandemic. Before we begin, we would like to thank Performance Food Group for hosting our program and providing lunch today. Now we'd like to recognize the generous support of our ability leaders: Triple H Enterprises, Dominion Energy, the Department for the Blind and Vision Impaired, Citrix, SD, the Virginia Credit Union, SCS Engineers, and of course, Performance Food Group. Also, a big thank you to Mike King for inviting Neil, Bob Lancaster, and myself on his radio show, Mike King Biz, to promote this event across the Richmond business community. On a programming note, we will hold a Q&A session with Neil at the end of his presentation. If you have a question, please raise your hand and wait for the microphone. We're videotaping the program, and we want to make sure your questions are being heard in the recording. Finally, please be sure to complete the survey, the post-event survey, on your desk. We value your feedback on how we can improve our educational programs. And I would be remiss if I didn't mention the one housekeeping thing: where are the bathrooms? So, if you exit these doors and take a left, they are on your immediate right after the entrance to the break room. And with that, I will turn the mic over to Neil.
Good afternoon. Hello. Thank you, Mark. I'm going to veer off from one thing Mark said. I don't like to just talk at people. So I would encourage you to ask questions as we talk through things and not necessarily say them. And I think it's probably more interactive, and everybody has most likely the same question that you do, so don't be bashful, and please interrupt me as often as you need to, but do be mindful of the fact that this is being videotaped, and I guess a microphone will be brought to you, right? So I was glad to see that there was a cookie in our lunches because it is the ADA's 33rd birthday on the 26th of July. This was of 1990. This was signed into law by President Bush. So enjoy your cookie. Also, last month was National Mental Health Awareness Month. And even though we've turned the calendar page, mental health issues were always there and will remain. So we're going to talk, the ADA is a broad law, and we are focused here today with the title that deals with employment, but there are also issues involving public accommodation, transportation, telephone communications, that kind of thing. But when we talk about employment, we think about the ADA, the first thing that always comes to mind is physical impairments. And that often is the issue. Oftentimes it's especially there's always back issues that we deal with and are the cause for litigation or consultations. But we're going to talk about mental health issues, which, as you probably know, under the definition of disability, it is either a physical or mental impairment that substantially limits activities. Now, we think about the things that pop in our minds when we talk about mental health, or the biggest ones that are prevalent these days, are anxiety and depression. But this also covers cognitive issues as well. So things like, you've probably heard the term neurodivergence. People think in different ways, and probably the best examples of this are autism, Asperger's, things like that. So those individuals that have those ailments would be covered by the ADA as well. So here are just some facts. As I mentioned before, June was Mental Health Awareness Month, and about 20% of employees reported a mental health condition last year. And when I was talking with Mark right before I came up here, I said, well, these things have always been around, so does it mean that there is more mental health issues, or people are reporting mental health? And I probably think, again, not based on any kind of scientific evidence, but I probably think it's the latter. Because I think in general, and you can see how people, they had asylums and things, and it was just, you're crazy or whatever it might be, and you're marginalized completely. But there is, it is a good thing that there's more openness about talking about it, addressing it. So these are all good things. But it does, it increasingly affects the workplace, and now we know about it. In the past, it might have been just an issue where somebody quits or got cited for some kind of performance issue, when in fact there was some mental issues at play. But now I think that the atmosphere is such that people are more willing to talk about it and bring it to the fore. So in 2021, 37.5% of the EEOC charges were based on disability, and of that, 30% were based on mental health conditions. Here's some other stats, and this is Virginia-centric, saying that about 25% of adults in Virginia have some kind of disability. Now this runs the gamut, as you'll see here. I'm not going to focus upon that too much. But again, this really, highlights the fact that it's not a minority issue, but it's an issue that affects the general population. During COVID, and I think most of us in this room probably had jobs in which we had somewhat of the luxury of working from home, and depending on whether you had kids at home, you might not have thought that was a luxury. I know that I know that I have to replace a dishwasher right now, and the repairman said, dishwasher. This is an old dishwasher. I said, it's only 5 years old. They're supposed to last for 10. And then I said, oh yeah, it was getting run 3 times a day during COVID, and it was probably painted full of wine glasses. So, these were some of the things that people reported: insomnia, feelings of guilt, irritability, sadness, just exhaustion, depression, anxiety. And during this, was a swirl of, not that these are also new issues either, but during the aftermath of George Floyd's demise, there was a lot of unrest, and we were front and center in Richmond. I'm sure in those days right after that, we all took the tour down Monument and downtown, and saw kind of the anger expressed. And again, this is Neil on the subject. Do I think things would have been that kind of out of hand if we weren't in the middle of the COVID pandemic? I don't think so. I think it was kind of the perfect storm. And now you're dealing with the aftermath of the perfect storm. Another thing I was just telling Mark, I said, there's 4 things that pop up in my mind that in the wake of COVID or during COVID, where there were more babies, or more divorces, more new puppies, and more better health ads that I've ever heard in my life. There's not a day that goes by where I don't hear about the availability of telehealth for therapy issues, and that's a good thing, because at the same time I'm also hearing that people can't get in touch and get appointments with psychiatrists or psychologists because they're all full, and a lot of them, and then this is a little off topic, but a lot of them are children, right? So this is all just kind of a background. Here's another slide showing the percentage of respondents that were exhibiting some of these effects. But it also translates, and that's kind of on a general basis, but it also translates into the workplace very directly. If people have poor mental health, sometimes they report poor physical health and call in sick more. There's more staff turnover. People maybe question the meaning of the purpose in their job more. And in some, especially in the industrial sector, if people aren't paying attention and aren't focused, it can lead to workplace accidents. And obviously, lost productivity and poor work performance. So it really is an issue that every employer needs to be cognizant of and really understand. And one thing that Mark highlighted when he introduced me was people call before they have an issue, or when they're having the issue, as opposed to when they get a lawsuit. That is certainly not always the case. Oftentimes, and I think I said this on the air the other day, I've many times had people shoot me a contract that was already signed, and then they said, well, is this legal? Does this look okay? I said, well, I guess it's going to have to at this point. You've already signed it. The same thing goes in situations where somebody's been terminated or discharged or disciplined or somehow, and rather than consulting first or considering these issues first, they acted in a knee-jerk reaction, and ultimately there was a charge of discrimination or there was a lawsuit, that becomes certainly a much more costly and involved endeavor. So we're first going to talk about the Americans with Disabilities Act. That's the federal act that applies to all employers, all private employers that have 15 or more employees, and all public employees, public employers, I'm sorry. And that was actually, the public part really was based on the Rehabilitation Act of 1973. But they're essentially one and the same. So really, at this point, we really just talk about the ADA. So the requirement is that no covered entity, which means an employer that has 15 or more employees, shall discriminate against qualified individual on the basis of disability in regard to job application procedures, hiring, advancement or discharge of employees, employee compensation, job training, and other terms, conditions, and privileges of employment. Now, I read all of that, and because I think more than most statutes, the ADA has a lot of these terms in and of themselves have their own definitions, right? So, what's a qualified individual? What is a disability? We have to kind of dig deeper into those definitions to get a bit better understanding. Now, a disability, looks like somehow we lost. Oh, here we go. Disability under the ADA. That is a physical, and I highlighted mental impairment that substantially limits one or more major life activities. Now, in, I don't know the year now, but a while back, the ADA was expanded by the ADA Amendments Act. So when we analyze most issues, I generally just start off with the assumption that this is in fact disability. it used to be that you would attack whether this somebody's claim was a disability or not, but for the sake of analysis, I think it's best to assume that it in fact is a disability. Now, usually, things like a broken leg aren't necessarily disabilities, and they can, and you can't, and even if you think that for a moment, you can't completely discount that, because if somebody seeks treatment from a physician or is out for 3 days in the hospital, then you've got concerns under the Family Medical Leave Act. And as we're going to discuss the Family Medical Leave Act, the Workers' Comp Act, and the ADA, they all kind of together. And it's not clear-cut. It's not. I mean, and that's why the kind of discussions are really important to have about this, because it is not just a flowchart answer. I mean, you can certainly be led by flowcharts, but certainly it's not the end of the discussion. And all these analyses are so fact specific. Going back, a disability refers to one, what I just read, a physical or mental impairment that substantially limits one or more major life activities, and that means eating, sleeping, walking, all these different things. It goes back to the fact that most everything we're going to assume to be a disability. Number two, a history or record of such an impairment. For instance, someone might be in remission from cancer, and now they think, well, he's had cancer, he might get it again. So we probably want to hire that person, because now our premiums are going to go up. And then the last one, and we're going to talk about this a bit more, an impairment perceived by others. And this is, I think, particularly important in the context of mental health, because so often we throw words around like, oh, they're schizo, or they're crazy. And we all play kind of the armchair psychologist. And we do it, and I've seen plenty of times where this has happened, and even if that person really isn't any of these things, if you treat him or her like that, or you say things like that, number one, you can have a claim of a hostile work environment, or two, that the person is being discriminated against on the basis of a disability. So really, while it's good to be kind of attuned to mental illness or signs of mental illness, you've got to be really careful about throwing those terms around and saying, well, you need to go see a psychiatrist. It's really not something that should be said flippantly. Get back on track here. And this is going to be the crux of what we're going to talk about today, reasonable accommodations, and the flip side of that, which is undue hardship. So employers must reasonably accommodate disabled employees to enable him or her to perform the essential functions of the job. Now, if a disabled employer, or it should be an employee, poses a direct threat, I'm sure sometimes people think that the employer is the direct threat, poses a direct threat despite a reasonable accommodation, then that employee is not going to be entitled to that. So let's break that down. First, essential functions of the job. This, and the starting place really should be, in terms of best practices, is that for each position that you have a job description. And that's good for a written job description. And one, let's say you have one, and this is so often where I see it, is not only in the context of the ADA, but oftentimes people say, we think we might have misclassified employees as exempt or non-exempt under the Fair Labor Standards Act. So, things like for workers' comp, for FLSA, for ADA, a determination of what's a reasonable accommodation, we really do want to see what the actual duties of the jobs are, and also not just think about, can you lift 15 pounds, can you sit for 2 hours or stand for 3 hours or what have you, but also things that are more cognitive. So things like prioritizing tasks, analyzing things, those kind of cognitive abilities that are part of the job. Now, I'm not here to tell you that it's an easy task to, I mean, think about if you all had to write out a job description of what you do every day. It's not necessarily easy, and it does take a lot of thought. And there are certainly those things that are essential, and then there are those things that are unessential. I mean, plenty of us do. A good example is, let's say, I had to do a lot of writing during the day, and I might have to use pencils. I might have to sharpen my pencils as well. But that's clearly not an essential part of my job. It's a marginal task at best. So, and just because in your job description that you say, well, this is essential and this is not, the EEOC is not going to necessarily take that at face value, but it's certainly helpful to kind of demarcate that as essential versus unessential. And it'll also depend on, let's say there's other people doing that same job. Do most people do these things as essential parts, or do most people do it, are they less essential for their positions? So there are other factors in determining whether something is essential or not, but that's kind of our starting point, because you can't reasonably accommodate somebody or have the discussion, which is known as the interactive process, unless you have a starting point. And the whole discussion, in order to determine whether there's a reasonable accommodation, or on the flip side, an undue hardship such that you can't give a reasonable accommodation, is what can we as the employer do for you as the employee to help us, to get your job done, right? And that has to be a back and forth. You know, I often will have other lawyers in my office come in and say, hey, somebody called me, they have somebody that has a disability of some kind, but they want to have somebody else there as an aide. But the cost of the aide is $25 an hour, and this person only makes $25 an hour. So clearly it's not reasonable, and clearly it's undue hardship. You have to really do the analysis, and you need to document that analysis, okay? It's not just kind of a thumbnail thing, and you make a determination unilaterally, saying, thumbs down, not reasonable, move on, or we're not going to do it for you. The interactive dialogue is essential. Essential. If you don't have it, you will be assumed to be discriminating against the person. And as we'll talk about later, the mere fact of not engaging in that under the Virginia Values Act is a separate cause of action in and of itself. So I can't stress enough the fact that you really have to have this back and forth. And the best thing to do really is you as the employer don't want to be the person ending the conversation, okay? So what I mean by that is if employee says, I'm having problems with depression and I take medication for it and it makes me very lethargic. So I don't want to have to come into work until 12 o'clock every day. Now, you can't just say, no dice, can't do that, and stop there. You want to keep the conversation going. Now, if the employee stops the conversation, I'm okay with that. But if the employer's stopping it, that's not a good thing. So rather than saying that, again, let's say the person is the manager in a bank and has to oversee the opening of the bank every morning, which opens at 9. That's not going to work, right? So an alternative might be switching schedules, as an example. But again, that kind of volley back and forth is really important. And to document that you've had that volley back and forth. And when I talk about documentation, I'm not talking about big fancy reports. And none of us retain everything that we hear each and every day. But if you don't remember anything else I say today, it will be, and I'm sure you've heard this before, document, 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 document. The people from the EEOC and judges have offhandedly said, if you didn't write it down, it didn't happen. And then the worst thing you could do is say, well, we're going to fire this person. And then I ask, okay, well, what have some of the issues been? And they say, well, I can make you a list. You don't want to make that up after the fact because it looks it is manufactured. And now you're looking at that and creating that through the prism of I want to justify terminating this person or demoting the person, or the case might be. So contemporaneous documentation is, I just can't emphasize it enough. And I did have one slide where I just think I wrote the word like 50 times on it, and I probably should have put 50 more. So we'll get back to that in a second. And again, right now we're really just talking about some of our tools, some of the black letter law that we have to work with. And then the second part is, you don't have to give reasonable accommodation if somebody is a direct threat. And a direct threat is a significant risk of health and safety to the employer. Okay? And again, this can't be a thumbnail, yeah, that person's a direct threat, we're not going to do anything. It's really got to be based on objective evidence that there's some kind of impairment. Now, one really good, and if you don't know about this, you should write this down, resource out there is something, and obviously talking to counsel, but also when it is really down in the weeds as to whether or not you can give somebody a reasonable accommodation. There's an organization that's called JAN. Does everybody know about JAN?
Yes.
Yeah. So if you have something, again, and I was telling Mark before, I said, you know, part of what I'm doing is just, I want your spidey sense to tingle when you hear certain scenarios, right? You might not remember everything we talk about, but you will remember this, you know, danger, Will Robinson, I need to consult with somebody. There's more to this issue than meets the eye. So that is a very good resource. But again, you're going to want to document, if you make a conclusion that something is reasonable or unreasonable or constitutes an undue hardship, you're going to want to document that. You're going to want to say, okay, let's say somebody asks for an Aeron chair. That's $2,000 because of the back condition. You're going to want to say, okay, at chair, $2,000, and then offer your things, and then, because you can't say, well, it's really costly, and then they say, well, how much was the cost? And you don't even know what the cost is. You can't really make that assessment. And I think, yeah, there's a list in the next slide of some of the factors that are kind of considered in this. Before I continue, are there any questions? Or everybody knows all this? Okay, all right. Was there a question? So obviously with mental health issues, you can't necessarily see it. And maybe people are more reluctant to offer it up. But I think it is okay. Number one, it's okay to ask the question, how are you doing? You know, you doing all right? Or I've noticed you've had issues at work. Again, those two first questions are very general questions and are just part of what we as humans do to interact with one another. But if you see some work performance drops or things that are kind of signs of depression or anxiety, it's kind of the general things that we're talking about, it's okay to ask that question. But it's not, as I said, okay to say, you know, you really need to see a psychiatrist. Or kind of, and a lot of times, it's not even, we're doing it out of the goodness of our heart because you're genuinely concerned about the person, but you know, that can be a double-edged sword sometimes. So, and when it comes to potentially saying that somebody should submit to a medical exam, number one, the employer would have to pay for that. And number two, you can't ask for a post-employment medical exam unless you can show that it is job-related and consistent with the business necessity of that position. And it's got to be an objective analysis of that. Oops, sorry. So undue burden is the flip side of reasonable accommodation. And you know, as I said, you can't just say, oh, well, this is this is an undue burden and make it a kind of conclusory statement. We've got to look at certain factors. So the nature and the cost of the accommodation. What are the resources of the company in general or that facility? It might be a separate line item budget. How many people are at the facility? You know, what are the effects on the expenses? What are the effects on the jobs and positions of others? What's the kind of operation that's at issue here? All these different things are the factors to be considered because it's not a pat analysis and really should be kind of a, I won't say a last resort, but it should be a determination that you make after exhausting kind of all other possibilities. Now, the Virginians with Disabilities Act, we're going to touch on just for a second because it is still in the law. The Virginians with Disabilities Act was kind of the baby version of the ADA. Just like the Virginia Human Rights Act for years, unadulterated was the baby version of the ADEA in Title VII. But I don't really see this come up very often, especially now. As you probably all know, in 2020, the legislature shifted employment law in Virginia dramatically with the enactment of the Virginia Values Act, which really overhauled the Virginia Human Rights Act. Before that, it was pretty much a toothless tiger, and in 24 years, I think I probably had one claim under that. So no one ever really paid that much attention to it because it only allowed for reinstatement, back pay of up to I think 25% of wages that was capped, and 25% of attorney's fees. So, you know, in the arsenal of what a plaintiff's employment lawyer had, they just didn't see the real benefits in it. But it's still around. I don't really understand why it wasn't repealed because now disability in 2021 was added to the Virginia Values Act. And so it now protects disability. And it is much more consistent with federal law on some level. But here are the things that are different. Now, number one, it can even apply to bigger employers. It used to be that Title VII would be from 15 on up, and the Virginia Disabilities Act would be less than 15. And now, even if you have 500 employees, nothing prevents you from being sued under the Virginia Human Rights Act. And one of the reasons that, and this isn't really going to apply here, so if you have 15 or more employees under the Human Values Act, you can assert all claims, and if you have between 6 and 14, just claims for unlawful termination. But the biggest thing, and this is more of a kind of a nerdy legal thing, is that you can bring this in state court as opposed to federal court. And the reason why that's important is because there's some features in federal court practice that are a lot more defense friendly. And that's something called summary judgment. And summary judgment is something that's actually available in state court, but for all practical purposes, no judge gives you summary judgment unless the plaintiff says, we don't care about that claim. So it's completely pointless. And the reason that employers move for summary judgment is because it stops the case from going to a jury. All right? Now, summary judgment basically is something that says, okay, we've taken our depositions and our interrogatories and all this stuff, and we agree on these are the facts that happened, but as a matter of law, employee or employer, you lose. All right? Now, because you could bring these claims now in state court where there is summary judgment, the likelihood of something going to trial goes way up. And then remedies. Under the ADA, just like Title VII, there's on compensatory damages, there are certain caps. So if you have 50 employees in your company, the most you can get in compensatory damages is $50,000. If you have between 51 and 200, it's $100,000, and so on. But under this, number one, there was a private right of action. Number two, it's unlimited damages. You can get $2 million in compensatory damages. And the only real limitation is in Virginia, you can't get punitive damages of over $350,000. So there's a lot of incentive to bring these claims in state court rather than federal court. Now, I will tell you that a lot of my friends that are plaintiffs' employers, they still bring lots of claims in federal court because they're just so used to doing it. But I just got last week an ADA claim based on failure to engage in the interactive process, and then to terminate this individual for $10 million in state court. And also, yes?
Quick question. So if you're a large business
Yep.
and you're headquartered in Virginia, and the employee that is bringing this charge is, say, out of state, can they bring it into state court because of where you're headquartered?
No.
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 So I have to do
No, I mean, if you're saying like,
I'm an employee, I live in Maryland, I work
Right.
at Capital One.
yeah,
Right.
and I don't have anything to do with, now, if there was some nexus to Virginia, other than the fact that Capital One also does business here, you can't just pick and forum shop and say, well, hey, Virginia looks like a good place to file a lawsuit, let's do that. No, you can't do that.
But based on its headquarters, what can I file where it's headquartered, right? Like Capital One's headquartered.
Well, I mean, by that, right, but by that logic, it has to be where the cause of action arose.
Okay.
Okay? Now, if there were some maybe decisions that were made from Virginia, that'd be another thing, and that'd be an argument. For generally speaking, it's going to be where the cause of action arose. Now, generally speaking, your personal jurisdiction, you might have heard that term, a lot of different factors go into that. In employment cases, it tends to be where the employees actually work. Okay? But that's a good question. So, and I know we're getting a little further afield, but it's really all these things that I'm telling you about the Virginia laws highlight the reason why it's so important to think about these issues and think of them in a kind of systematic way, because the stakes are higher, and I don't see, unless there's a large change in the legislature, which I don't see coming for some time, I don't think things are going to just revert back to, I'll say, normal for quite some time. So, what kinds of things can you just do generally speaking? You can revise and it's always a good idea to look at your anti-discrimination and your anti-harassment policies. In general, it's also a good idea to look at your handbooks on a periodic basis. And make sure everything, as I said before, is documented. Also, and as an actual litigator, I'm not the biggest fan procedurally of arbitration, but it really depends on the circumstances. In employment disputes, it probably makes more sense to have arbitration clauses. I've got one race case that's in arbitration right now. And the reason I say that I'm not a big fan, if it's a business versus a business, I don't see any point. But the obvious advantage in arbitration in an employment dispute is it's not out in the open. Now, the fact that it's in arbitration doesn't mean there's some kind of force field around it. Employees talk, right? And there's nothing that prevents that person from saying, hey, I've got this arbitration against the company right now. But it certainly does, at least from a public perception, give some more protection. I guess I'm personally not as big a fan of arbitration just for rank and file employees. Probably more with C-suite employees more than anybody. But I do know that many large employers have arbitration provisions for all employment cases. But as you know, that they're also very expensive, because as opposed to litigation where you're paying Mr. Lawyer and maybe other fees, if you lose, you're paying the judge too. And some of these arbitrations have 3-judge panels. And if I've got a commercial dispute right now where we don't really have a leg to stand on, and the arbitration's in New York City. 3-judge panel, 3 arbitrator panel, and you're looking at probably between $800 to $1,000 an hour per arbitrator. So that adds up pretty fast. And then something that a lot of people use, and you probably have heard more about severance and release agreements lately, especially because of the National Labor Relations Board and them saying that there has to be carve-outs to make sure that people's rights under the NLRA aren't being violated. Using severance agreements. I do it all the time. It's a way to, you might not like it, but it's a way to kind of manage your risk and at least get rid of the, well, I might be getting sued, I don't know one way or the other. That's kind of taken care of. So, what can we as employers do? I think one is something we talked about, which is, having a kind of changing our culture. Moving from the, if anyone saw the movie Roadhouse, pain don't hurt kind of attitude of, and saying, it's okay to say, I'm dealing with some issues in my life and it's affecting me and it's affecting my work. So changing that culture, providing EAP to employees, or making sure that there's health benefits in your health benefits policies as you're shopping around. Again, workplace policies, which are first and foremost. A lot of times people are looking at sabbaticals, and obviously it depends on the kind of workplace you have, but sabbaticals or people always used to say this in college when we just wanted to skip class, taking a mental health day. Little things like that. Not necessarily a mental health day, I wouldn't call it that. Please don't do that. Just saying, once a year, the company pays for, massage or some kind of relaxation. Now, these are just ideas. These aren't certainly, you have to do that. But really, everything comes from the top, right? The top is what sets the tone, and you kind of, practice what you preach. And that's, I think, the most important thing. What are some of the reasonable accommodations that tend to be most prevalent in the context of mental health? Telework. Now, I will tell you, the EEOC after, or during, I should say, COVID, and you all probably were going on that site because, especially for the Corona, I don't even remember the name of it anymore, the Response Act, where within a week they imposed all these rules on us and nobody understood the rules. And I'd answer the phone every day and say, what does this mean? And I'd say, we can only guess and do our best because I don't know what it means. Matter of fact, nobody in this country knows what it means because there's no guidance. And they just threw this up against the wall because expediency really was the watchword at that point. But the EEOC took the position that post-pandemic, telework was not necessarily a reasonable accommodation. Now, I take the position that I don't know how you spend 3 years with people working outside the office, and now all of a sudden they were doing the jobs, and now it's suddenly unreasonable. Right? I mean, there's not a week that goes by that there's not some article about people coming back or hybrid or remote. I did something this morning all about remote work. And having people out of state has its own issues, right? Because now you're subject to not only your state's laws, so I spent 5 hours the last 2 days looking at Indiana laws and all the different things that were going to impact this one person, including posters. Now, none of these laws, your workers' comp poster, your unemployment poster, your minimum wage poster. So I guess some guy now sitting in his home office in Indiana has to put posters on his wall. So, I mean, none of these employment laws were ever implemented with that thought in mind. But I have a hard time getting back to the issue. I have a hard time understanding how all of a sudden magically telework can't be a reasonable accommodation. Now, the only pushback, and I think that really is fertile ground to have a discussion on interactive process, because there is that push for people are quiet quitting, or there is need for collaboration. Or clearly, if you're working on a manufacturing line or you're working in a warehouse, you can't tell them. We got that. But that also goes back to what do we put in our job description. And if we're going to say you can't telework, or we're going to say what you have to do, we have to include words about needing to be physically present. You can't file if you're at home. There are certainly things where you need to be in the office, but you need to have that starting point of why. Show me where that's required and why that's part of the job. White noise. We still have them in the house, and I still sometimes sleep with them. But people, if you're now easily distracted, white noise machines, or even the plexiglass barriers, not to prevent from COVID so much, but for noise and distraction, those are all things that are good. Leave obviously is a big one, and then schedule changes. Things you don't have to do. Well, one other one would be moving somebody temporarily to a vacant position. What you don't have to do, you don't have to create a whole new job for somebody. You don't have to say, okay, these tasks were essential jobs of functions of your job. You no longer have to do that. You don't, as an employer, have to bend over backwards to that extent. But I just gave you a smattering of the things that might be accommodations, but I can't. I think to give you an exhaustive list would be a disservice, because it is so heavily dependent upon the facts and circumstances of the case that just a laundry list, a how-to guide, just would be impractical. And the other thing, as I mentioned before, JAM is a really, really good resource. And I mean, that's what they do. So are there any questions? Oh.
On your previous slide, the best mental health practices for employers, can you elaborate on positive outcomes?
I think,
Can you repeat that question?
Yes, on the last slide, best mental health practices for employers, if he could elaborate on positive outcomes.
I think it's kind of, for lack of a better phrase, kind of celebrating victories, meaning rather than saying, well, we made this accommodation because we had to, it's look at how we can accommodate our employees and how we've done it. Maybe not naming that person, but how we've done it. And these are all the other, it shows flexibility. Showing your wins is really what I mean by that. A couple things I also need to just touch on. Throughout this whole interactive process, to the extent that you are requiring a examination, which again needs some discussion before you do that, or when you're getting information from the employee's physician or other practitioner, is under the ADA, that's all got to be kept confidential. So it's got to be on a need-to-know basis. As you all know, if you have personnel files here in this cabinet, you need to have segregated files with respect to health information in a separate cabinet. And that goes doubly, the only people that should really know about these things in this interactive discussion would be the supervisor, the HR person, and the employee, whatever team members need to know. And that's really important, because you could inadvertently, walk into a claim of violating that protection by not doing so. Does that answer your question about positive outcomes?
Yeah, I just wanted to know what you
Yeah.
say positive outcomes.
Yeah.
I do have another one. Is there documentation that is required to consider a reasonable outcome? I'm sorry, a reasonable accommodation. So if somebody comes and says, hey, I need a new chair because I've got a back issue, is that just something we can move on, or what stops everybody in the office from saying, well, is there something we should require?
Well, I mean, it depends. I mean, you certainly can, you know, say, you know, what, I mean, are you saying like a doctor's note, is that what you're asking? Yeah, I mean, so long as it's consistent with job necessity. I mean, certainly you want to guard against people kind of gaming the system. And that's fine, but it's got to be really narrow, right? Only with respect to what's being asked. You can't say, I want to see all your medical history. It's got to be very discreet.
This is in relation to some of the, I work for the Department of Rehab Services, so we work with employment people with disabilities all the time. One, you mentioned essential functions of the job. The other statement that seems to get a lot of our folks that have issues with is under the job descriptions, there's usually a line, and we all have it, that says other duties as assigned.
Oh, yeah.
Yeah. No,
And-
I agree.
Yeah.
And I tell people to put that in there because you don't want to be locked into somebody saying, it's not my job description.
Exactly. Well, the thing is, depending on the disability, and I'm talking about folks that are very literal, maybe folks on the spectrum, that unless you have it written
Oh,
down,
I understand.
they're going to say, it's not my job. So I guess I'm curious as to, especially now with minimum wage has gone up to $15 an hour, nobody is going to be able to pay anybody to do,
Well, not yet.
One or
It's
two
not
things.
that much yet.
well, you know what I mean.
Yeah.
But we've noticed that the trend is for, that folks that used to be able to do one or two things, now it's expected to do 5 or 6 things, and a lot of them fall into that other duties as assigned, and there's a rub, and I didn't know if you had any comments on that.
Well, I mean, I think it depends what the context is. You know, if it is a situation where if someone is working in fast food, and it says, and I pick a lower tier job on purpose because it's probably going to be the context most of the time. Yeah, your businesses in general are having to do more with less, right? And they need that flexibility. But I understand your point as well. Now, if somebody is in a situation with their boss and saying, I'm not going to do this because it's not in my job description, that's an insubordination issue, I think. And that person would be subject to termination on that basis. But now if you're saying, there's that leeway there in the context of a reasonable accommodation, and you have to really think about what is the additional task that's being asked, right? And can we subdivide it within the essential versus margin? If it was, now you're going to have to clean the fry bin once a week, as opposed to, you're also going to have to reconcile the day's receipts. Those are two very different things, and depending on the job. So it's a good question. It's a really good question, actually. But I think that's really the best I can do because there's no easy answer.
I just had a couple of comments that we have seen a dramatic increase in our short-term disability claims and our ADA claims that are mental health related. And a lot of folks, and it's really post-COVID. I mean, some during, but telework was available. Now it's, maybe not. We're moving towards hybrid. And immediately they want an accommodation because they have to come back into the office. And most of those have been mental health related, anxiety, stress. So just more a comment that yes, we are seeing that with our staff. But also under best practices, we have started a couple of items for really directing towards mental health. We have Self-Care Wednesdays that we're sending out evidence-based practices that people can do for self-care, just to try to give another tool to our employees. And then we're starting some training on workplace psychological safety so that folks feel more comfortable coming and talking and that it's a safe place to work. So those are some tools that are touching that mental health side of the workplace. So I
Yeah,
just
you know,
wanted
the
to
other-
share those.
The other thing to kind of think about is, there's more gun violence, there's more things that happen in the workplace with guns. And then, this happens so much in employment, which you're stuck between a rock and a hard place, right? You have, under the general duties clause of the OSHA, you need to, take reasonable measures to keep your people safe. And then you become kind of hyper vigilant and you think, well, this person seems mentally unstable. He or she might bring in a gun and kill. You can't really act on those ambiguous, vague kind of concepts. This might happen. But at the same time, you don't want to say, well, I've documented everything, but somebody's been shot, right? So it's a difficult and difficult thing to navigate. But I mean, the best I can do is, to the extent you have those concerns, really kind of check yourself to say, what am I basing this on? That's the best you can do. Obviously, if I would suggest, and I'm not trying to be political, but I would suggest not having a no weapon policy. Now, even in my own old firm, one of the employees said I could do whatever I want for the right to carry statement. I'm like, not here, you're not. So unfortunately, those kinds of interactions happen because of these countervailing issues. Is there another question? Did you not get my cookies? Well, if that's all, I see that we're right out of time. Maybe a minute early, a minute or two early. The last thing I'd say is my firm every year does an employment law update, which is an all-day affair. In the past, we've done 3 live presentations. This year. We're kind of getting back. We're trying to dip our toe back into having live presentations. We're having a live presentation on August 2nd in Hampton, and there's a virtual one in October. So the live one's actually, it's full. We have the most attendees that we'll ever have, almost 200. But I do have brochures outside if anyone would be interested in that. And just like this, I forgot. Here's the activity number for your SHRM credit. But I'd encourage you, if you or a colleague would have interest in attending our seminar, that would be great. We have people from the Department of Labor, from the EEOC, and other various state and local government officials, as well as plaintiffs' employees to give their perspectives. And most of all that attend have given us positive feedback. So that information's outside. But I appreciate your time today, and I know I'm probably the last thing standing between you and the weekend.
Can you go back one
Oh, yeah.
Thank you.
And I'll just read it out. It's 23 S as in Sam, 6 Echo Sam.
Thank you.
Thank you.